Let's go to the next one, the tax Dabble trap. And this is basically a belief that a business lawyer can advise on some or any international tax transactions, international tax issues rather, related to business tax transactions, even though he is not a practicing tax attorney. Oftentimes, this belief comes from prior experience. Meaning a business lawyer had, let's say 10 years ago, he was involved in a similar deal. An accountant was present. The accountant advised on this deal. The lawyer remembers what this advice was, and he decides, it's a similar deal. Why do I need an accountant? Why do I need an attorney? I can do it myself. And he starts advising on tax issues, believing that his advice is exactly the same as it was 10 years ago. Perhaps a contributing factor to this belief is a bit of hubris, which is present in all attorneys, myself included. It's if you remember the song, anything you can do, I can do better. Anything I can do anything better than you. It's exactly that kind of attitude, and that's exactly that kind of attitude which is completely false in international tax law. You cannot dabble in international tax law for two reasons. First, it's extremely complex. You may think that this advice that was given to you 10 years ago by an accountant or even a tax attorney is correct. But perhaps there were some details, something in the facts of that particular case that influenced that advice. And in a different situation, which might be very similar, but yet slightly different, and that slight difference may make a world of difference in terms of what kind of advice should be given. And the second reason is that this is a tremendously dynamic area of law. The law, international tax law, changes all the time. Today, you don't have to report this asset. Tomorrow, there are 3 reporting requirements. Yesterday, it was not taxed. Today, it's taxed. Yesterday, it was entitled to long-term capital gains treatment. Today, it's not, or vice versa.